Today, we begin the second part of the course. When we were talking early on about what is international law, we said that international law could also be considered comparative law, comparing legal traditions and rules across systems. And so that's what we are doing today. We're going to start looking at legal systems, and we're going to begin with Western legal systems. Now, before we can talk about the law, we actually have to talk about what is the role of the law. What is it that the law is doing? And maybe you never thought about it, but what role does the law play in our world? Well, in fact, the law is doing two different things. At any point in time, the law is doing two different things. And the first is the law regulates relationships between the state and its citizens. If you've ever watched a TV drama involving a criminal show where there is a court, you've probably seen or heard the case is always referred to as the state versus Smith or the state versus John Doe. And the reason why is the law is regulating the relationship between the states and the citizens. When a citizen commits a crime, that is a crime against the state, against society as a whole. And so therefore we have this body of law, criminal law, that applies to that relationship. But we know the law also regulates relationships between individuals, that when two parties enter into a contract and one party fails to live up to its obligations under the contract, it is the law that provides a remedy. We can, if we are the injured party, the aggrieved party, we can turn to the state and say, look, this party has broken a contract, therefore they owe us restitution. So the law is doing these two things all the time. And what this section of the course is about is that every society faces these same problems, that every society requires a system of rules that regulate relationships between society and its citizens, the members of that society, as well as a system of rules that regulates interactions between those members of society. Now, over the centuries, the world has developed different legal systems that perform this same act or these same acts, but in slightly different ways. And so what we're going to be doing now is to examine, first of all, the primary legal systems or families of law in the world. And we start with this idea of how do the world's legal systems compare? That this study of different legal systems is known as comparative law. And as I said, every state struggles with similar issues. And those issues may have to do with business. How are sales and purchases made? How do a buyer and a seller relate to one another? It could relate to family matters, marriage and divorce. It could relate to criminal matters. Every state faces the same issues, no matter where they are or who the population is. Every state has to deal with these same issues. And so countries need a body of rules, a means of dealing with these problems. Now, there are hundreds of unique legal systems created to address the problems of the particular society that has created the system. However, these hundreds of legal systems tend to break down into certain categories. And we start, first of all, with there are two broad divisions of legal systems. And the first is a religious legal system. Religious legal systems originate from a deity. A god or gods has provided a set of rules, and these rules will apply to society as a whole. The other type of legal system is a secular legal system. And secular legal systems originate from the people. The people are the ones who are going to decide what is the law. We're not going to rely on a deity, but we're going to rely on people themselves. So there are two broad divisions of legal systems in the families of legal systems. Now, there are different ways of classifying legal systems, and the first one we're going to talk about is called the civil law. The civil law is the most widespread form of the law, and we'll be talking about where it came from, but civil law places an emphasis on writing, written law. Much of Western Europe is based on the civil law. There's the common law as well, and we'll talk about common law as it's developed primarily in Great Britain and the United States, but the common law could apply, again, worldwide, generally to those countries that have some political connection to the United Kingdom or England. And then finally, Islamic law. A fourth of the world's population is Muslim. Many of them live in countries that have a religious legal system based on Islamic principles. We're going to spend a lot of time talking about Islamic law in a separate lecture. There are customary law. There are places in the world where the law is derived not from statutes or from cases or from a deity, but instead the law is derived from custom. What is a customary practice? And of course, there are many countries that have mixed legal systems, systems that incorporate different families of the law. So for instance, in a country like South Africa, there will be elements that are based on the common law because of its heritage as a former colony of England, but then there's also going to be many elements related to civil law. In Israel, we see, again, an overlap of law. There's the modern civil law. There's common law preserved from its elements from its time as an English protectorate. And there are religious elements, religious law applying as well.